Representative Hobbins, members of the committee, my name is Mark Bergeron. I'm the Division Director for Land Resource Regulation at the Maine Department of Environmental Protection, speaking in opposition to LD 1750. You have my testimony that Ms. Dixon is passing out now. What I would like to do is highlight some of the things, and again, my testimony is based on the original bill language, not the amendment that was passed out today. We oppose this bill because we already do these tasks that are described in the bill, and as Commissioner Aho just mentioned, it would prevent us from making the necessary findings for wind energy developments. Let me explain the process a little bit of how we do it. We accept applications for wind energy developments. We review those application materials against the required standards in the Wind Energy Act. Things like wildlife impacts, scenic impacts, noise, those sorts of things. By law, we are required to make an individual finding on each one of those standards. We can't balance, say, noise impacts against wildlife impacts. We balance impacts, or we balance the standards of review based on the information in the record for each standard. So say the applicant says, we don't think it's an unreasonable adverse impact for scenic. We have some other comments from other parties say that we think it is unreasonable for those reasons. We hire, say, a third-party expert to provide us some technical expertise on the review of that information, and we take all that information in the record and make a finding, make a determination based on that information. I would like to point out that our third-party experts don't have all the information in the record. That's the department's responsibility, is to make that final determination. It is not the third-party reviewer's responsibility to make a determination on the project. It's only to provide us with the technical expertise that department staff doesn't have. Some of the other things that I wanted to touch upon were the tangible benefits. As Commissioner Aho mentioned, tangible benefits aren't just energy and emission related. They're defined in the Wind Energy Act as construction employment, local purchase of materials, natural resource conservation. Those are other things that the department is required by law to make a finding on. So to say that we wouldn't be able to request that information from applicants would hinder our process. And since the statute presumes that an expedited wind energy project provides energy and emissions related benefits, the department may not find that those benefits do not exist. This does not mean that the department may not or should not discover and make findings regarding particular aspects of those benefits. Additionally, I do want to point out that the Wind Energy Act requires annual reporting of tangible benefits. This may make it possible that that information is not available after the project is operational, so it would be either difficult or impossible for the department to provide that annual reporting to the legislature as required by the law. Thank you for your time, and I'm happy to answer any questions either here or at the work session.
Thank you, Mr. Bergeron. Questions, Representative Russell.
Thank you, Mr. Chair, and thank you for being here. I should have mentioned this to Commissioner Aho for the work session, but since you're talking about the adjudicatory hearings, there I said it, it's like saying statistics. I would love, so the President, when he presented his testimony, said very clearly he would be open to finding ways to ensure that public input was adequate for this process. And knowing him as I do, I know that he does care very much about transparency and public process. So I'd be curious what the department would bring to the work session constructively to talk about how to make sure that we're preserving that public process and hopefully making it even more accessible to people. I'd be very interested to hear. I know you're opposing the bill and as it currently is written, but I like to have some constructive dialogue, not just a no, so to speak. So I appreciate that.
Sure, and we could see what we could come up with for the work session on that. I would like to comment that public comments and public input is very important to us throughout the process. As Commissioner Aho mentioned, we accept comments from the public, wherever they may be, whether they're right around the project or halfway across the state. If somebody has a comment that they want to get to us on a wind energy project, they can call the project manager, they can email the project manager. Up until the time we make a decision on the project, they can give us information. They can provide us with that local information that would be helpful to us. All the comments that we receive via phone calls, via emails at the public meetings are entered into the public record, and we take those very seriously and support a strong and robust public comment period.
Representative Dumpy and Representative Rikerson.
Thank you, Mr. Chair. Mr. Bergeron, if this bill passes, does it simply become, and I need to simplify it for me, not for you, does it simply become a matter of crossing the T's and dotting the I's? And it seems like it hamstrings your ability to really get to the root of the issues, and just sort of throws this out there as, you know, if the application's filled out correctly and signed, then it's a done deal. Am I oversimplifying this?
I don't know if you're oversimplifying it, but I believe it would prevent us from making some of those findings regarding tangible benefits. And again, taking all the information that's in the record, because when we review specifically a wind energy project, but any project that we review under the Site Location of Development Act, the Stormwater Law, even a wetland impact form under the Natural Resources Protection Act, we start with the statute. If the statute isn't clear, then we go to the rule. If there's nothing in the rule, then we look at the basis of information that's in the record. What is in the record that we can use, that we can weigh appropriately to make a determination, again, on each and every one of the standards. So I think that's an important process to the department in these projects.
Thank you, sir.
You're welcome.
Representative Rikerson.
Thank you, Mr. Chair. Thanks for coming. I don't mean to beat a dead horse here, but I do want to know specifically more about the projected impact on electrical rates in the host communities, because I'm looking at the Wind Energy Act, and I see system reliability, I see total capital cost effectiveness, but I don't see anything that really refers to the impact on the electrical rates in the host community. So I'm wondering if, I don't expect you to dig it up now, but maybe in the work session you could in the future find out where that interpretation, where that rule, or that, it's not a rule, it's a required submission came from the Wind Energy Act specifically.
Absolutely. I can provide you that information under 35 MRSA, Section 3451 under definitions. Tangible benefits, I don't have the page number, but tangible benefits means environmental and economic improvements attributable to, it goes on and so forth. Then it lists a number of things, including but not limited to reduced electrical rates. And that's the basis that we use to say, give us the information based on your project, what it will do to meet that statutory requirement. Yes.
Thank you.
You're welcome.
Other questions? Representative Knight.
Thank you, Mr. Chair. I'm looking at your testimony, and I'm trying to decide what this sentence means. Statute presumes that an expedited wind energy project provides energy and emissions-related benefits. How is that supposed to affect your decision?
I'm not sure how that affects our decision, but that's one of the statutory requirements of the Wind Energy Act, that we have to make presumptions that there are energy and emission-related benefits to the project.
So,
Yes. Representative Knight.
so is that supposed to be given extra weight or equal weight,
similar, well, I won't say it's similar to scenic impact standards, but that the Wind Energy Act was written specifically to include those benefits for energy and emission-related standards. I'm not sure if I'm answering your question, but...
I'm not sure.
Other questions for Mr. Bergeron? Seeing none, Mr. Bergeron, thank you for taking your time to be here and for your testimony.
Thank you very much.